All right. All persons have the business before the honorable chief judge and associate judges now presiding at this time in the court of appeal, draw near and give your attention. God save the United States, and it's on the court, it's now in session, please be seated, come to order.
Great. Good morning, and our apologies for starting a few minutes late. Welcome to the District of Columbia Court of Appeals. We have some visitors and guests in the audience. The appellate advocacy class from American University School of Law, welcome. And their professor, Senior Judge Judy Bartnoff from the RTC Superior Court who teaches. So welcome. We have 3 cases before the court this morning. Our first case is, I guess I should just take a moment to say I'm joined this morning by Judge Corrine Beckwith on my right and Judge Lauren Ali Khan on my left. So good morning. Our first case this morning is Ingleside LLC versus Santorini Capital LLC. Counsel, are you ready to proceed?
May it please the court, Vanessa Carpenter-Laurie, I'm counsel for the appellants 1814 Ingleside LLC and Christopher Harrison. Our appeal is based on, number one, the denial of a motion to dismiss, which we think was an error, a granting of a motion for summary judgment, and the award of legal fees, which we think was an abuse of discretion. Santorini filed basically a complaint for a breach of contract on 2 promissory notes that were secured by a residential building. At the time that they filed the complaint, DC had enacted DC Code 423191.01, which was the Coronavirus Support Temporary Amendment Act of 2020.
And if I could just sort of get to the point on that. Where in that statute does it say that the litigation can't be brought or must be stayed? I know it has a couple of mechanisms for waiving late fees and other charges, but I don't understand how you get from that statute to an outright dismissal of the case.
So it's not that a case can't be brought. We believe that they failed to include necessary allegations to indicate that they complied with the provisions of the code prior to filing the complaint. And that's why I started with, they just simply filed a breach of contract. I think given the requirements of that act, they were required to say that they offered a deferment plan and it was not complied with. I think that would have been an essential part of the case.
I read the statute as saying the consequences of failing to follow those sort of measures about late fees and payment plan was that you could lose your mortgage license, not that you couldn't bring litigation.
Well, I think I respectfully disagree. I think it was incumbent upon them to comply with those provisions in order to proceed with the complaint, because essentially they were saying there was a default of the mortgage of the 2 promissory notes, essentially. But I think that if my clients had been given the opportunity to enter into a deferment plan, that would have had to have been a part of what they included in the complaint.
Does the statute put the burden on your client to request a deferment plan, and did they do so?
They did so, and that was a part of the record at the trial level, that there was a request, there was information provided to the.
At what point, I know there's a sequence of events where Santorini requested to accelerate the mortgage payment. After several missed payments, they requested to accelerate payment on the loan, on the full amount of the loan. But then there were a couple of renegotiations where they extended it, I believe in November or October and November of 2020. At what point in the sequence was the request made to Santorini specifically pursuant to the Coronavirus Relief Act?
So, Your Honor, prior to the filing of the lawsuit, there was an issuance of a notice of default. And we contacted Santorini and indicated that, the statute was in place and that we were asking for a deferment plan, and actually provided them with a copy of the statute. That was before the lawsuit was filed. And that's why we think the lawsuit was kind of in bad faith because there was no effort, even though they knew prior to filing the lawsuit that we were asking for compliance with the terms of the statute.
So did the extensions that I'm referring to, which I believe were in November of 2020 and October 2020, those came
Before,
after?
they came before.
Mhm.
So that's why we
So
took
those
the
don't
position that,
count
I'm
And
sorry.
those don't count, I'm sorry, in your view, as efforts to work out a deferment under the
No,
coronavirus?
actually, that extension, it was offered and put into place prior to the act being enacted, actually. So I can't remember the dates right now offhand, but I know that was before, and that's why when they sent the default letter after the fact, because there was a default, there's no dispute about that in terms of the payments. But because the act went into effect, we sent the letter saying, okay, this act is there. My client is entitled to a deferment plan, and we're asking for one, and we provided a copy.
But is there a provision? I thought there was a provision of the statute. This is why I'm trying to get the sequence that said that the act does not apply to some of the defaults that occurred prior to implementation of the act.
I did not read that. The way I read it was it went into effect, I believe, October 9th. And the extension for payments was through October 31. So the loan was still in place in terms of when the maturity date was going to take place at the time that the act went into effect. So I think that's why the act applied. And basically, they wholly failed to do anything in compliance with it prior to filing the lawsuit.
So what is the date on which the loan balance was initially due and accelerated?
Your Honor, I don't quite remember when it was initially due. I know that there was a default early on, probably prior to March of 2020, I believe. I'm not sure of that.
So I guess the reason I'm asking, and you I think probably know this, is under subsection I of the statute. It says that the coronavirus provisions don't apply when the mortgage lender either initiated a foreclosure action or exercised its right to accelerate the balance and maturity date of the loan on or before March 11th, 2020. And it seems like here it was in maybe even 2017 or 2018 when the balance was first accelerated and due.
But I think the fact that they then extended the maturity date nullified that aspect of it. I mean, they don't dispute that they extended the maturity date to October 31, 2020.
So you see that as resetting the provisions?
Exactly. And so I think that the court was in error and dismissing it simply on the basis that mortgage loans were not a part of the debts that were stayed, the collections were stayed pending.
Did you read the trial judge's decision dismissing the case to mean that because these were mortgage loans, they're not subject to the Coronavirus Act, or because they were extended beyond the March 2020?
No, I read his ruling, and I think he just specifically says that there was no stay on collection actions for mortgage loans. And I'm not arguing that there was a stay on collection for mortgage loans. My argument is that prior to proceeding, or at least proceeding, would the mortgage lender would have to complied with the Coronavirus Act and offered a deferment plan. If that was defaulted on, then that fine, you could proceed under the rules, but the judge didn't even address the impact of the Mortgage Relief Act.
Right, but wasn't the extension, I guess, couldn't the extension by the like Santorini LLC to the end of October of 2020 be considered a deferment plan under the coronavirus statute?
No, because it specifically required certain things, and that included a payment plan. There was no payment plan, basically.
This was just a balloon payment,
It was
everything.
Exactly. It was just a balloon payment to be due now in October, on October 31, 2020. The act required a lot more than extending the maturity date. It required criteria and procedures for borrowers to even apply for a deferment program. That was not done. And getting to the next point, there was, in the complaint, they asked for specific amounts of money based on the default of the mortgage. The act required waiver of certain fees, interest, that was not complied with. At least there was no indication in the complaint that was complied with. There was never any
a really
indication.
interesting question. So I do take your point that the judge overlooked that the act may have caused there to be, you know, late fees waived and things of that nature. Did you ever propose a competing figure in your opposition to summary judgment or dispute the amount that they were seeking in their proposed order?
Well, the summary judgment was a separate issue. If you look at the motion, they never said in the motion what the amount was, not in the affidavit, not in the statement of facts, and not in the argument. As I indicated, and as the record indicates, the only place they put an amount was in the proposed order. And I think that is wholly insufficient under the rules. But the problem is because
they didn't say that in your opposition, did you? Because I think there's sort of two subpoints here. One is that they had the burden to establish that there was no disputed material fact on the amount that they were requesting. And I think on that point, the fact that they didn't put it in their affidavit, I take that as a very strong point, but you don't make that argument in your opposition. The argument you make in your opposition is that the COVID Act would have cut into that figure in some way. And I guess I'm wondering, what do we make of the fact that you didn't make the larger argument of their failure to carry their overarching burden? And then secondly, what do we make of the fact that you didn't propose a counter figure as to what you thought would have been owed once you deducted all of the fees from the COVID Act?
Well, I believe I did make that argument, and I'll look at, my motion, my opposition, but it was no way for us to do that. All we could do was say they made this allegation of this amount being owed at the time they filed a complaint. My client filed an affidavit saying he made payments since the filing of the complaint. So we had no way of knowing where they got the figure from because they never, ever provided an itemization of this was the principal, this was the interest accrued, these were the late fees that were accrued.
But why would they have been in a superior position to do that? I mean, you knew what the loan was, you knew what payments your client had made, and you knew what the terms required for late fees and interest. And so I guess I'm just curious why they say you owe us, what is it, 1.39 or something? Why didn't you come back and say that's disputed? Actually, we think that maybe the amount is $900,000.
Well, Your Honor, I think that if you are the complainant, you have the burden of proving what your claim is and what your damages are. And our responsibility as the defendant would have been to then come back and say those numbers are incorrect. It's just no way for us to calculate that. I mean, the numbers were all different in each pleading that they filed. And I think it's their burden to show for the court definitively, this is what our claim is, and this is how we came to it. And then we have the burden to say, no, that number isn't right. And these are the reasons the number isn't right.
But this was on summary judgment. So how would the trial court have known that there was some dispute?
The trial court didn't have a number to even assess as indicated. They didn't put any number in their motion. They put no number in the motion. The only number was in the proposed order, and the affidavit doesn't say a number. And as indicated, we had no way of knowing how they came up because the number was different than the number that was in the complaint. So I think that the burden should have been on them, and I think that the case law indicates that the burden should have been on them to tell the court, this is the number that we are entitled to, and this is how we arrive at that number. To just take a gross number and say, okay, you proved it, and the affidavit doesn't even say that that's the number. So I just think that for purposes of the motion for summary judgment, that was just insufficient.
I know you wanted to reserve a couple.
Yes, I
minutes for
do.
rebuttal.
Thank you.
Thank you.
Morning, Roger Simmons for Santorini.
All right. Good morning, counsel.
May it please the court. And I'm a member of this bar for over 50 years, and this is only the second time I've been in front of this court. It's a pleasure to be here today.
Well, welcome back. Good to see you.
Too long, too long. Your Honor, this is, and these are allergies for this is not COVID. I took a test. I apologize. This is a basic underlying commercial loan situation where Mr. Harrison, the former football player, took out and he has a very successful and profitable construction company. Took out a loan from a secured lender, a Santorini private bank, a Santorini Capital LLC. Applied that loan to rehab some property in the District of Columbia. And after the case was decided below, while it was on appeal, he put the property on sale and got its full value plus a healthy profit. During the course of those negotiations, it was agreed that a number would be paid to Santorini and full settlement resolution of the loan between the parties. We pointed this out in our motion or suggestion to move this. And apologize, I got my tie out. The case at that point really resolved the underlying issues. But going back to the,
Well, I guess part of the underlying issue is the contention by the plaintiffs that at the very least, the amount of attorney's fees and the amount in dispute that was actually owed by Ingleside
yes,
wasn't
yes,
properly calculated. And in your pleadings before the court, you referenced, I think in your appendix at page 80, that you had a statement of monthly payments that were in arrears. And counsel for appellant is claiming that that was never really a part of the motion for summary judgment and therefore didn't give the trial court sufficient basis to grant the summary judgment motion in your favor with the amounts that they awarded.
the amount that was awarded was based upon the underlying business documents that were testified to by affidavit were true, authentic, and in place and applicable.
So
We
I understand that the mortgage documents did say what late fees and other things would be owing, but I guess assuming that the COVID statute did apply, didn't that necessarily waive some of the late fees and perhaps affect or modify what would otherwise have been contractually due?
Yes, Your Honor, during the period of the statute and in our opposition to the motion to dismiss, we pointed out that we were not asserting any right to fees during the late period. And we did not include that in any calculations. That was never disputed. The Ingleside parties and the Harrison parties never disputed that the Santorini had not sought anything during the statutory period.
Well, in their opposition to summary judgment, they do say that they thought the amount was in dispute. It seems like they say there's a disputed issue of material fact as to the damages owed because assuming the COVID statute applies, certain things come in and out of the equation. And so at that point, wasn't it incumbent upon you to put in an affidavit or put in some sort of Excel spreadsheet showing why you had substantiated the amount you were asking for?
It certainly would have been nice to have that clarified, but the truth is when they simply say it's in dispute, you don't know what they mean. They didn't file an affidavit to put it in dispute. It's not a material fact in dispute until you have evidence supporting that claim. They did not support the claim. They did not present their argument in a way that presented the issue for the lower court, nor for this court. And I apologize for my voice. I've been on a vent too many times to have one left here, but I appreciate your court's indulgence. The truth of the matter is that they never disputed the idea that we had given a deferment. Creating some kind of time payment plan.
What was the deferment?
Yes.
Are you saying that you gave a deferment, but not in accordance with the coronavirus relief statute?
Well, no, that's not Not what I was trying to say, Your Honor. Far be it for me to tell the court what this statute required, but this is not a home mortgage. It's not a time payment statute. It doesn't involve time payments. It's a situation where he rehabbed the property and sold it for a lump sum payment.
So your
And we
view is-
did give deferments. I'm sorry.
I'm sorry. Your view is that the coronavirus statute is not applicable to the kind of loan transaction that was involved here? Or are you saying the deferment that you gave to Ingleside was sufficient to comport with the coronavirus statute?
It's the latter. I don't contend one way or the other whether the statute applied this or not, but as to the deferment we gave, it was fully satisfied of what we did before the case was filed. We gave the deferments. We extended it. There was not one dime paid that was ever asserted or really proven by Mr. Harrison or Ingleside. He said they made payments, but he never said what. And we're not aware of any, and we didn't rebut
So,
that because there was no proof put in that he did.
I'm looking at your statement of undisputed material facts. It's a JA 79 and 80.
Yes,
And,
sir.
it seems to me that in a customary contract suit, you would have the amount of damages if you thought it was undisputed in your statement of undisputed facts. But all I see is the amount of the original notes.
Oh, the way it was approached here was young lawyer presenting what he thought was the correct way. And unfortunately, he's not here to defend that. I look at it and what I understand him to be arguing is all of the business documents and the minimum calculation were put in by affidavit as verified documents. They were applied in the normal course of business in the way brought this calculation. The parties didn't disagree with that number. The property was sold and it was resolved in that sale transaction.
So the amount that you initially sought in your complaint is different from the amount you sought at summary judgment. Do you know what the difference was accounting for? My understanding is the complaint asked for 1.278 and the proposed order asked for 1.373. So there's about a.
As I stand here, I cannot answer that question. I'd have to research.
Can I turn you to the attorney's fees question?
Certainly.
So in my sort of prior life, when I was looking at fee litigation, I didn't see redactions of the sort that you have here. So it seems like there were some very, very heavy redactions made. And didn't that sort of hinder the trial court's ability to really discern whether you were charging reasonable fees and even whether you were charging the proper fees?
There was never any objection to the redactions. The court never asked us to do that, but in granting the fees, he cut our fees in by more than 50%. And he could well have taken that into account. I know that he exercised careful discretion when you only get $15,000 in fees in a case that you spend 45 doing. There's been a discretion applied.
For discretion to be applied, though, there has to be sort of an intelligible principle. And here the trial court said that your billing lacked sufficient detail to adequately explain the work performed.
Well, I think it explained the work. It didn't explain the underlying legal issue that was protected by attorney-client privilege. And that was the purpose for the redaction. And the court didn't dispute it, and it was not objected to by the other side. So it's not an issue I can really present to the court as having been preserved for appeal.
I mean, they objected to the fees, and I thought they did specifically say that they could not even tell what was going on based on the redactions.
They other than a general complaint about fees, that's all they ever said. It was never specific. It was never fact-based. It was never disputed as to any particular redaction. So there was not a way they could respond to that.
Counsel, can I ask you, I know you made a point initially of saying that there may be an issue of mootness here because the property was eventually sold. If the summary judgment and the motion to dismiss were ruled on in error as your counsel for appellant argues, would wouldn't this still be a viable issue for us to proceed with?
I can't imagine how a court would get involved in a transaction that's closed. And this is what the point we were trying to make on the move. These two parties went into a commercial transaction, obtained money to build a rehab facility. And the facility was in fact sold for a substantial profit. Mr. Harrison and his company made significant money on it. Mr. Harrison and his company and his title people and the buyer all were three-party agreements to the amount paid to Santorini to resolve their underlying mortgage. What is there left for the court to say about it? And possibly some instruction to go back and relook at the fees. We could do that and submit the detailed information on the fees, but I submit that would result in getting twice the fees we got than standing where they are.
That would be a good thing, though, wouldn't it?
I'm sorry,
I said,
Ron?
wouldn't that be a good thing for you?
Yeah, it might be, it might be. And I wouldn't be opposed to a remand for that purpose. I think the judge went a little too far, and if you want to have him go back and get the fully unredacted set and look at it and make a revisit to that, I'm not opposed to that, but I don't think it's necessary here.
All right.
Because there was no real fact dispute on whether those fees were properly incurred.
All right. Thank you. Anything further?
No,
counsel?
no, Your Honor, I stand on our briefs.
Thank you very much.
And I think we have some very fine briefs, including the opposition to the motion to dismiss that Mr. McKinney prepared for me. It's just a superb young lawyer. And Mr. Tubla likewise did a good job on the rest of the briefing. Thank you very much, Your Honors,
All right. Thank you.
and I appreciate your consideration. I apologize for my lack of voice. Thank you.
Okay. All right, Ms. Carpenter-Laurie, you have a couple minutes for rebuttal.
Yeah, I think I have a couple of minutes left. I think that with respect to the fees, we did exhaustively go through why we think that the application was deficient, not only because of the heavy redactions as indicated by the court, but there was a lack of information about the attorneys that worked on the case. There was an indication that there was an agreement for a certain hourly rate, but there was an indication on the ledger that those hourly rates were different than.
So you're just, it sounds like requesting a remand for recalculation of the fees awarded, not a reversal of a grant of summary judgment in favor of Santorini?
No, I'm asking for reversal of the summary judgment. Going back to that a little bit, we indicated that we did file an affidavit from Mr. Harrison indicating that he in fact made payments after the complaint was filed, and that the court ordered, granted summary judgment for the time for reply, so that Santorini never even addressed the issue of whether that factual allegation was true or not. So I think that the even granting it was premature, because I think that Santorini should have been required to respond to that allegation. The fees, I think, shouldn't have been awarded at all, because the affidavit and the motion was so deficient and with respect to the compliance with the rules. And I think the court's order indicated that, and the court just simply said, I'm just going to cut it in half because this, you know, it was just deficient. With respect to the mootness issue, I think that the case cited in the court's order denying the dismissal for mootness, the Martin Development Company versus Keenan Construction, indicated that if the court can award monetary damages, because in that case, the court upheld the appellate court upheld a part of the monetary damage award, but indicated that another part of it should be reversed because there was not sufficient proof to sustain it, and therefore the appeal wasn't moot because there was relief that the Court of Appeals could grant.
What's the practical impact here where the property's been sold for a profit, and the profits and proceeds, I guess, dispersed for various reasons?
I think that the cases basically that indicate that mootness applies is if there's no way to grant relief. And so the cases are, complaint for possession where the property was sold and the court can't grant possession any longer. The capital cab, I think it was capital cab, I can't remember the name exactly, but they put themselves in a position during the course of the appeal that they couldn't win because they had reduced their fleet so much that they couldn't comply.
But here. what's the
Here, you
practical
don't have that.
implication?
Here, well, my client was entitled to whatever profit he, that was obtained. That's not the issue. The issue is whether he was entitled to more proceeds because he overpaid the loan that was not properly documented in the judgment that was granted by the trial court. So the court does have an option for relief. And again, I think I indicated that one of the things that occurred during that settlement is that Santorini demanded another almost $70,000 in legal fees. The court had ordered $15,000. So that money is sitting in escrow now pending a resolution by this court as to whether Santorini is even entitled to get that money. So I don't think that it's moot. This court can grant relief because I think
I'm
that.
curious, how is it that those fees that are in escrow are before us? All that's on appeal is the judgment and the $15,000 attorney's fees. Anything that happens subsequent, I think, would have to be the subject of a new appeal.
The parties entered into an agreement that it would remain in escrow until this portion of the dispute is resolved.
Okay.
Thank you.
All right, thank you. Thank you both for your briefs and arguments today. We'll take the matter under advisement.
Your Honor, the agreement spoken of is not for the court, it's the title committee. It has nothing to do with this case. Thank you.
Thank you.
All right, our second matter today is DESEAN HATTIX versus DC Housing Authority. All right, counsel, are you ready to proceed?
May it please the court, Betsy Crum here on behalf of appellant DESEAN HATTIX. I'd like to reserve 5 minutes time for rebuttal.
All right, thank you.
This case is about whether the attempted failure to register a firearm is a per se threat to the other public housing tenants' health, safety, and quiet enjoyment of premises so as to prompt an eviction under the one strike policy. DCHA cannot be given carte blanche to evict tenants who have committed any gun offense anywhere at any time with no individualized review of the actual circumstances in any given situation.
But isn't it in the lease that if a tenant commits a crime or possesses guns, that they're subject to eviction under the one strike rule of the Federal Housing Authority, since DC takes federal funds, but also under the provisions of DC Housing Authority's own lease?
If there's been criminal activity, but that criminal activity must have been a threat to the health, safety, and quiet enjoyment.
Isn't a gun inherently a threat? We did have some testimony from the property manager here that there was violence in the area, particularly of this particular public housing unit, and there were concerns for public safety. Why wouldn't that be sufficient here?
Yes, Your Honor, that would go to the individual question of whether there was enough, but is a gun a per se threat is what was fashioned by the lower court. And no, I do not believe a gun is a per se threat. I would say there's three different ways you can look at this that discuss the per se threat issue. First, you can look at registration itself, and the attempted crime here, we also need to remember, is attempted failure to register a gun.
Yeah, that's kind of a head bender for me. It's
Yeah.
basically an unregistered firearm, right? That's in his home. No testimony that he was brandishing it, using it under Heller and some of the recent cases following it in this jurisdiction. Isn't it, well, it's not unlawful necessarily to have a firearm in your home for protection under Heller, is it?
That's correct. It is not unlawful to have a handgun in your, or many types of guns as are laid out in the statute,
But it's unlawful to have an unregistered handgun.
it is unlawful to have a unregistered handgun. That is correct. But I would suggest that if you look at the registration statute and the purpose of registration, it in and of itself is an individualized process. So again, handguns are lawful and Heller deemed them the quintessential weapon for self-defense, and they must be registered, but the registration process is one that considers not the weapon, but the person who will be utilizing the weapon through a series of questions and different standards that individualized person has to meet. So to suggest then that an inquiry into whether a tenant who's been convicted of an attempted failure to register, which I agree is a bit of a head scratching offense, but that is the crime committed here, doesn't deserve the same individualized review that is being considered when determining registration is just unjust and unfair.
Isn't it when you in your brief describe this, you characterize this as not registering firearms, but isn't that, different from possessing an unregistered firearm or just looking at it more the way the government is looking at it? Because the way you look at it doesn't take into effect all of these things that go into registration, which the government is arguing, and Judge Edelman argued about the significance of training or all the things that are required to get registration that arguably go to safety issues. Are you are you resisting that registration has anything to do with safety?
I am not resisting that registration has anything to do with safety, but I do think, to your point, it's important to look at attempted failure to register a gun. One of the underlying elements of that crime is not possession. And at no point in anywhere in this record has possession in the legal sense been established. It is required under HUD guidelines since 1991 that DCHA, when planning to evict a tenant because of criminal activity, while there doesn't have to be a conviction, they do still have to prove every element of the underlying crime here. One of the issues that's been, problematic throughout this entire process from the trial court through the briefing is that we and Mr. HATTIX are referring to the actual crime he was convicted of. That's what's on the JNC, which is attempted failure to register a firearm. And DCHA has been referring to the plea, which is a different crime, which was attempted unlawful possession of a firearm. And so there's just a serious disconnect here in terms of what elements would even need to be proven by DCHA, because two different crimes are being talked about here.
Can failure to register happen without possession?
It is not, possession is not one of the underlying elements of the crime.
As a logical matter.
Well, yes, I think it can, because you could still be intending to own a firearm. You may be seeking to get a firearm, considering them, and then you fail to actually go through the process of registering them. And given that possession, actual or constructive, requires that a court consider whether there is a voluntary and purposeful intent to have that gun, and it's not by mistake or accident, then and that hasn't been proven here, the concept of possession still needs to be something that would be addressed, and it has not been addressed at any point in this matter.
Where is that in your appellate brief? This is a new argument.
Well, Your Honor, in our appellate brief, we have continually discussed that there are 4 elements that need to be proven. We did, I will admit, focus on the 3rd element of whether it is a crime that affects the threat, is a threat to the health, safety, and quiet enjoyment of the premises. But this issue was discussed in the motion for review, Appendix 283, which is a discussion of the fact that the conviction that happened here is not what was pled to.
So the language of the statute says that each public housing agency shall utilize leases which, among other things, provide that any criminal activity that threatens health, safety, or right to peaceful enjoyment of premises by other tenants, or any drug-related criminal activity on or off the premises shall be cause for termination of the tenancy. So the question is, does failure to register a firearm, which is a crime, right?
Yes.
Criminal activity, does that threaten the health, safety, and peaceful enjoyment of the property?
Right, and that is the crux of the issue here, and I would suggest that it is not. Simply pointing to a conviction or criminal activity without establishing a nexus to the health, safety, and quiet enjoyment is exactly what the court in DCHA versus Whitfield deemed insufficient, which I know, of course, Your Honor is familiar with. Mere documentation is not enough.
Right, and in Whitfield, the concern of the trial judge, I understand, was that there was not a sufficient nexus between a criminal activity that occurred off the premises of the public housing unit in question. Here, there perhaps is a little more nexus because the gun is in Mr. Hattix's unit and it is unregistered. And there is some testimony in the record from the property manager about concerns about guns and other criminal activity and violent activity in the overall premises of this housing community. Why isn't that a sufficient nexus? What more here would need to be shown? Because I think I tend to find persuasive some of your arguments about the need for more of a nexus rather than making it a simple per se violation. But what's missing here though? Because I think there's a bit more of a nexus in this case than there was in Whitfield from my assessment.
Yes, Your Honor. First, I would just note that it was my understanding that the nexus in Whitfield, because the court does say that there could be crimes that happen off the property that still do threaten tenants on the property, that the nexus here is whether the crime itself affects the health and safety and quiet enjoyment. And again, I note here that the crime here is a attempted failure to register, essentially.
Well, it's attempted possession of an unregistered firearm.
Well, again, that is what Mr. Hattix pled to. It is not what Mr. Hattix was convicted of.
Where is the JNC in the appendix?
I believe it is 167. So 166 is the plea, 167 is the JNC, and then there's an amended JNC, but it only amends as related to community service.
And
it doesn't
I'm
change
sorry
the
if you
sentence.
said that, but why did that happen? How did that distinction happen? He pled, okay.
That was a great question, Your Honor, and something that frankly should have been addressed at trial. It would have been, again, going to more of the individualized circumstances of the facts of what was happening in this case, which we don't know. And here we are now with this disparity and attempting to make per se rule, or to your question, back to the individualized circumstances. What we have here again is mere documentation of this plea, which is different than the sentence. And then we have one person's testimony of a property manager who the majority of her testimony was actually her talking about what other people had told her during meetings. And it's frankly just inadmissible hearsay. Otherwise, what we have is her statements of generalized statistics of the area and nothing more. Generalized.
Whether or not it's hearsay, could you talk about its relevance? Is it clear, is there authority kind of for your suggestion that the this, if we're talking about the individualized threat, that it has to be really about this person's specific conduct or, as opposed to what's going on in the neighborhood or in that particular complex.
Sure. I mean, I don't have a specific case authority that I can turn you to, but I would just suggest that if we're talking about an individual and their crime and whether they should be evicted and, homeless, which is a pretty severe result, it really ought to be based on the actual conduct of that individual and whether that conduct has affected the actual area. And in this instance, we don't have any information that the conduct of Mr. HATTIX has caused any of the other tenants has threatened their health, safety, or quiet enjoyment. And in reality, the actual testimony that we have is that Mr. HATTIX has been an asset to the community, that has a great relationship with the property manager, that the property manager has no knowledge that he's ever been involved in gun violence, and that the one time that he was involved in gun violence on the property is actually when he was almost shot trying to save a child. So the information we have is that his conduct has been nothing but.
But isn't that part of the problem here with this record? I know I'm flipping back and forth as I think about this issue, but we don't have more information about Mr. HATTIX because he didn't register the firearm. Part of the DC's registration requirements would have been to determine whether he had mental health issues, whether he had taken the proper training to safely use the handgun, whether he had a criminal record. We don't know any of that, which we would have known if he had properly registered the firearm. Isn't that true?
That is true, although we also might have known that if he were allowed to testify to that at the trial below, which questions were asked and an objection was sustained.
Is your view that no gun crime is a per se threat?
I think, again, gun crimes vary so much in their underlying elements that it's hard to make a per se rule. However, I think you could look at guns that are not permissible at any point, such as assault weapons or things that you can't even register. And perhaps owning one of those, possessing one of those would be, one could fashion a per se rule off of that because there is no circumstances when those are allowed. And I would like to just save a few minutes for rebuttal.
I don't want to speak for the chief, but I'm sure we'll give you time. But could you talk speak to what extent does Heller affect your argument, and can you talk about the applicability of Scarborough to your case, as your opponent relies on it quite heavily, and can you explain why that's not right?
Sure. Scarborough, of course, counsel is relying on footnote 9 specifically of Scarborough, which had said that the mere presence of an unregistered gun or an unlawful gun, I believe, is a per se threat. However, that case was decided before Heller. And so at that time, when the case was being decided in the District of Columbia, all guns were unlawful or
that's not
effectively
quite right, because like retired law enforcement officers, and so it seems like Scarborough could have come out quite differently if it was a legal handgun, even in a pre-Heller situation.
Yes, that is true. And it was, there were exceptions at that time, of course, but it still was not, there were not exceptions for general citizens for the most part. And so Heller then comes in along from the Supreme Court and says, and essentially forecloses this inference that a handgun is a dangerous and unusual weapon. There's a lengthy history in Heller about all the different types of weapons and what was permitted and not permitted, but they come to the conclusion that a handgun, which is the quintessential weapon for self-defense, is the most popular, and folks are allowed to constitutionally own that with restrictions, of course, registration. However, that changes, I believe, what Scarborough is saying, because Scarborough was, again, at a time when District of Columbia wouldn't have even allowed handguns in that manner, except for the few exceptions.
So you think that Heller means that just mere possession, unless it's established that it's an assault weapon or something that can't be registered, just can never be a per se violation?
I believe that
like any possession offense or possession related offense is not a per se violation.
any possession is not a per se violation. Any possession of a lawful gun. And so again, I would say that guns that are not allowed, a machine gun, an assault rifle, something along those lines under 7250501 could of course be considered a per se threat. But that's not what we're talking about in this instance. We're talking about handguns that could have been registered.
Now, so it seems like the fight or the crux of this is over, not whether guns are dangerous, that ship has sailed, but over, whether the lack of registration, whether you want to call it attempted failure to register or possession of an unregistered gun, is itself a threat somehow. But it seems like before the magistrate judge, that wasn't really what was being discussed. I see Judge Edelman got into it more, kind of focused in on that being the question. And but do you agree that that wasn't really how the magistrate judge was looking at it? And is that a problem?
I think it is a problem. I think that goes back to exactly what I was discussing earlier, which is to say that there are essentially two crimes being addressed here, and it's not even clear which one, even though the one Mr. Hattix was convicted of is attempted failure to register, and the one that both the trial court, Judge Edelman and Judge Boucher, as well as DCHA are relying on, is this plea, which is unlawful possession. But possession is actually not what we're discussing here because it's not what he's been convicted of.
I guess I'm wondering if there's like an evidentiary problem with the assumption that having an unregistered firearm is dangerous for all the reasons, you weren't trained. This is why we set up a registration system to kind of control access and make sure that the people who have guns are going to use them safely. Now, that's an argument that supports the position, but it seems like it's not necessarily based on, empirical evidence or even testimony. Is that?
I'm sorry, what is not based on empirical evidence or testimony?
There's no, there's an assumption in Judge Edelman's order in particular, and maybe in the government's briefs, that about the dangerousness of the absence of, of possessing an unregistered gun. I'll just use that as shorthand, even though I understand you're now disagreeing with that. And is that just, is that part of what the other side of your fight? Is that, do you agree that that's the argument you need to meet the force of?
I do. And I think you can, there's hypotheticals you can come up with, which, think of instances where you could be in possession of an unregistered gun and you wouldn't be a threat, even though you haven't gone through the registration process. The most simple being that perhaps I own a gun and I've registered it, and then I buy a second version of that exact same gun and forget to register it. So now I've already gone through the process. I've already done everything that I'm supposed to have done that says I'm allowed to own this. I am safe to use this type of gun, but now I haven't done it a second time. Am I now really a new type of threat for that reason? I would suggest not.
Questions?
Okay.
All right, well, we'll give you a couple minutes for rebuttal as well. We've had a lot
Thank
of
you.
questions on this one. Ms. Dessel? If you need to, you can adjust the podium.
I'm okay, thanks, I think. Good morning, may it please the court, Alyssa Dessel on behalf of the Housing Authority. This case is not about the constitutionality of the registration requirements. It's not about the right to possess a weapon. It's about the obligation of the Housing Authority to enforce the lease to protect its communities, and to suggest that having an unregistered weapon, and there wasn't a dispute that there was an unregistered weapon in this case, is you only have to turn on the TV, look at social media, read a newspaper to see the effects of having weapons in the District of Columbia.
Well, that's also going to be true. Sorry, that's also going to be true in, Houston or other large cities and states that do not have registration requirements. And if there are so many states, large cities in this country that don't even require registration, does that make your argument harder that it's just per se threatening, it's a per se threat to not register?
I think in the District of Columbia, what we have to look at is the purpose of the registration statement of the registration law. And the District of Columbia has enacted that law, and it did so based on the fact that registration laws promote safety. And the defendants don't dispute that. They say, and they agree with that on page 8 of their brief agreement. Clearly, guns are dangerous. Guns are dangerous whether they're registered or whether they're not registered.
Well,
That was-
if this gun were registered, then what?
If this gun had been properly registered, we wouldn't have brought this case.
Right, and so-
However,
yeah.
the reason for the statute is to ensure that people who have guns have gone through the process to make sure that they are part of the group of individuals that have been deemed to be safe to have weapons, which then reduces the threat of danger of that weapon. So
But is it
in-
fair post Heller to rely so heavily upon the notion that guns are dangerous?
Heller never says that guns aren't dangerous. Heller says that you can have, just as Judge Campbell ruled in the Wanda Thomas case, that the Constitution allows you to have this very dangerous object under certain circumstances. The circumstances here were not met, and the defendant did not register and deliberately did not follow the procedures of the law. So
Have you, do you, and I apologize if this is in your brief, but are there any cases, appellate published cases, not Superior Court cases, that hold, the possession of an unregistered gun is a threat to the health or safety under the first,
not specifically that we found, and the cases really that were cited by defendants really don't apply to this situation, because the Perez case, the Melendez case, those were all cases that where the criminal activity was off the premises, just as it was in the Whitfield
the
case.
Perez case doesn't seem quite right. Because the court in this case, it never says he didn't threaten anyone's safety specifically because he wasn't on the property at the time. It says, which is the violation of the defendant's obligations. Such conduct does not constitute grounds to terminate the defendant's tenancy under Section 9 because there was no evidence that he engaged either. Then they repeat engaged, not good grammar, engaged in conduct that threatened the health or safety of a BHA tenant, BHA employee or person residing in the immediate vicinity of public housing, or engaged in violent criminal activity on or off BHA property. It doesn't seem like it's only, clearly specifically confining its holding to off premises conduct.
The language in the statute and in the lease in that case stated that the activity had to be a specific threat against the tenant or employee or someone on the property. I think the standard for their violent criminal activity was a little bit different, but that was not what that part of the decisions went to. I think the issue here is that the city council determined that the registration process directly reduced the threat of having a gun. And that was because they would go through this process of all of these different elements that someone would have to show to be able to show that they were able to have a gun. The purpose was to take the distinction between two groups of people who were qualified to be registered and people who were not, and apply them in a way that protects the people and reduces the threat that a gun poses. So the court can look to whether or not you're registered to determine whether or not someone has an increased threat.
I guess that, I understand the logic of this, but there's just not really any case law supporting it. And, like in our court, DeBose, which I was on that case, and I think that case involved, basically saying the crime of possessing an unregistered gun is, survives Heller. And it goes on to talk about how registration has this, long history, and it's been part of, it basically talks about history and doesn't say anything about why, basically the main things that you're focusing on, how it ensures safety.
Well, and then that's what goes to the threat, but I don't think that, and I think the case that we rely on is the Scarborough case, where the situation was that there was an unregistered gun found on the premises with ammunition, same facts that we have in this case. And the court held that that was a threat, that having that weapon in the premises when it wasn't registered was a threat. And I don't think it's just dicta, and I don't think it's just in a footnote.
Well, do you think
And-
that case would have been the same post Heller?
Yes. Yes, because the purpose of the registration is to promote safety and prevent threat. And so Heller did nothing to overrule the facts in Scarborough, despite the defendant's assertion, and Heller never says that guns aren't dangerous. And so therefore, if you haven't registered your gun and gone through all the steps to show that you're someone who should reliably have been allowed to have a gun, the threat is increased. And the threat is increased by someone who isn't registered.
Couldn't you still achieve the purpose of the statute by going through an individualized proof when these cases arise, rather than the shortcut essentially of saying no registration per se danger, per se violation? What's the harm of the additional steps when these cases are brought to say this defendant, Mr. Haddock, didn't register and was in fact a dangerous and threatening person for the safety of the community because of whatever, other type of evidence or testimony that still gets you to the same place, maybe with a few extra steps, doesn't it?
I don't think that we're required to show an individualized threat. There's nothing in the statute that says what type of evidence has to be presented in order to show that the conduct is a threat. And I think that the conduct here, having an unregistered weapon, is the threat that was engaged in by the defendant by his failure to register.
So how
And
do the regulations, we're talking about the federal one strike provisions, and the regulations that work with that provision require what? Once there is a conviction or a notice of criminal activity or evidence of criminal activity, then the housing authority is notified. In this case, MPD had a warrant, made an arrest, notified the property manager that there was this gun, and then as you interpret the statute, what provision sort of allows you to just say you're out?
the lease allows that you to say you're out because the housing authority is not required to show a conviction. They're not even required to show an arrest. All they have to do is show that the defendant engaged in criminal activity. And here, the criminal activity that the defendant engaged in was having that unregistered
Criminal
weapon.
activity that threatens the health
Yes.
and safety of the,
And it's our position that. the
so if he had
threat-
stolen televisions
I think
in his apartment, no per se violation because you don't. There seems to still be a nexus requirement is what I'm getting at
Well, I
here.
think the purpose of the statute in stating that you had to show a threat was to eliminate a housing authority from asking tenants to well, was it from evicting tenants when the types of crime had no relationship to the property? So,
Or to the health and safety of the
right. So for
property.
example, if they had engaged in credit card fraud, or if they had had graffiti, or were operating a business or
But-
something like that.
Exactly, but that's, I guess what I'm getting at, it, the kind of nexus that you have to show requires some level of proof of a threat and danger to the health and safety of the community.
And the nexus here was the fact that the defendant had this dangerous weapon, which was unregistered in his unit. And the housing authority can't be required to wait until something happens, until someone's killed, or until someone uses that weapon.
Well, when it's a registered gun, they're waiting, right? Or why is that different?
It's different because that gun is legal.
But
And
you
that's-
keep saying it's still dangerous.
It is still dangerous. But you're allowed, as Judge Campbell stated in the Wanda Thomas case, the Constitution allows you to have something dangerous under certain circumstances,
Right.
and those certain
So
circumstances
your
weren't.
view essentially is that it would still, a legally registered firearm would still threaten residents' health, safety, or right to peaceful enjoyment. It's just not criminal activity, so it doesn't trigger the provision of
Right.
subsection 1.
It does not. While I don't think you need to reach an individualized threat to the community here, because I think that the fact that he didn't register this weapon, which was what the entire statute of registration was designed to promote. While I don't think you have to reach that, I think we did reach that in this case. And I think Ms. Harvell's testimony, which was not hearsay. She's the manager of the property. She's there every day. She sees what is happening at the property. She witnessed hearing gunshots at the property.
What about the part of her testimony that is saying what other people told her?
Well, as the manager, she's required to take information and complaints from the tenants and from the resident council. And I think that if you look at the judge's decision, she discounted certain parts of the testimony, and I don't believe that her decision was based on those parts of the testimony.
Does
And I
it
think
say
when you're-
that, or what is that? Does the decision say that?
In her actual ruling, I don't believe she actually mentions Ms. Harvell's testimony at all. I think Judge Edelman touched on it a little bit in his decision in denying the Rule 73 motion. But I think that the cases in this court say that if you have the difference between the fact that this was a bench trial as opposed to a jury trial allows this court to believe that the judge knew the evidentiary rules and was making her decisions based on the proper evidence that came in. And she did question Ms. Harvell, and she did go through her testimony, and there were certain things that she didn't allow.
What about the relevance of Ms. Harvell's testimony when you think seems like it would apply again to a registered gun on the property? And it doesn't, there's nothing specific as to Mr. Hattix's own conduct, and what little we hear about it seems to kind of cut the other way. Now, do you just fall back on well, if it's registered, it's not criminal activity?
Well, I think that she did not, and I agree, she did not state anything specifically that Mr. Hattix did. He wasn't brandishing the weapon in the premises as far as we know, or using it in some other way. But the danger is that he had this weapon and it was illegal. I know that that goes to the per se argument, because I don't think you need to get to the individualized argument. But the mere fact that there is this gun on the premises increases the threat of harm. Anytime you have a weapon that's not registered because the person has not gone through all the hoops that you would need to do it, is an increase in the threat
What do you think
to the
of
community.
I'm sorry to interrupt, but what do you think of Ms. Crum? Is it Ms. Crum's hypothetical about the person who just jumped through all the hoops to register one gun and then has another gun, so and hasn't registered that?
I think you'd have to have more facts to determine, that situation, to see what type of gun wasn't registered, whether it was the same thing. And, people's circumstances change as well. So whenever you are going to possess a weapon, you have to go through the registration process, because we wouldn't have known if maybe he now no longer qualifies for the requirements under the registration statute.
So,
Maybe he's had, I'm sorry.
I think we keep kind of floating back and forth between per se and individualized, and there's not a lot of case law on this. And so in your experience representing the housing provider, what other types of crimes are sort of per se, or is it just kind of gun violence? I guess, to what extent do we look at per se versus doing an individualized analysis in each case?
In my experience, the crime that we focus on as a per se threat are the gun violence, are the gun cases and the unregistered gun cases, because there are an enormous amount of unregistered weapons. The other types of cases are usually more the drug-related eviction cases, and those are easier to prove because you have the drugs, you have the police officers who can testify that the drugs were illegal and where they were found. And for drugs, of course, they don't even.
Does that really work in a per se fashion? So for example, I think if you are, you've got a meth lab going in your DCHA unit, I think we can say per se that's going to violate, or threaten residents' health, safety, or right to peaceful enjoyment. But what about smoking marijuana? Let's say it's illegal in the district at that time, or when it was illegal in the
It
district.
actually is still illegal under the federal regulations, and therefore for public housing tenants, it is illegal to have.
And it is per se, you think, that just someone smoking something that's otherwise legal if they didn't live in public housing necessarily threatens residents' health, safety, or right to peaceful
I
enjoyment?
think it's per se because the drug-related activity does not have the qualifier that it has to be a threat. That's not part of the lease violation.
Gotcha, okay.
Can I ask, and maybe this is not part of the record, I don't recall, what triggered the search warrant for Mr. Haddock's apartment unit?
It wasn't entered, the affidavit in support of the search warrant wasn't entered. But I believe, if I recall correctly, that it was based on a confidential informant giving the police information that there were drugs and guns in the possession of Mr. Haddock's. Based on that, they searched the unit and found 2 weapons with ammunition and I believe some drug paraphernalia. So that's how that
Thank
came.
you.
What, just go back. So we believe that the registration statute, which controls here, does show that anytime you're not registered, the threat you have to the community is increased. And I think that the housing authority, who's tasked with the obligation of protecting their communities and their residents, must follow that. I would suggest that no one can possibly believe that guns are not dangerous. That's why the city council determined those registration requirements. Failure to register is an indicator that you're a greater threat rather than a lesser threat.
Sorry, I hate to keep dragging you back to the per se question, but I'm confused.
Okay.
So for drug-related criminal activity off premises, is that per se, or do you have to have a nexus?
No. And any type of drug-related activity, the lease provision and the federal regulation says that drug-related activity on or off the premises is a violation.
Okay, and that in your view is per se, one strike, no opportunity to cure.
That's correct. And I think we need to remember too, that the violation here was solely within the defendant's control. If he had registered, we wouldn't be here, but he didn't. And that choice led to triggering the statute. The Supreme Court has recognized the one strike statute as meeting the goals of keeping communities safe. The basis of it is even more necessary today based on.
Wait, what are
unprecedented-
you reading from? Or,
Just mine, no.
oh, okay, I'm sorry. I'm, one thing.
That's what I made up. not-
Yeah, one thing I'm really interested in is, authority to support the notion that the lack of registration is a threat. And I wondered if there's, is there any DC law, statute or case in any context that defines, unregistered gun as dangerous or violent crime. I understand you and your opponent have, you're back and forth over the definition of violent crime and whether that's relevant or not. But is there anything out there?
There isn't a case that I found that specifically goes to that point, which is why I think you have to look to the purpose of the registration statute. And the purpose was clearly to promote safety, and the purpose was clearly to state that it's an indicator of a threat if you're not registered. I think that we shouldn't have to wait until something terrible happens to be able to pursue someone who has an unregistered weapon in their apartment unit. And I would urge the court, I see my time is way up.
I'm sorry, can I just ask one more question?
Yes.
Is every criminal activity where you can look at the purpose of the statute and say that it's to promote safety, is that translate into it's a threat?
Well, I think there may be types of cases where that wouldn't apply, but when you're talking about a dangerous weapon like a gun, I think that you do have to look at it.
Yeah, I just keep thinking this is a runaround Heller though, because a dangerous weapon is,
Heller never says that guns aren't dangerous. They say you can have them.
Yeah.
In fact, it's clear that people wouldn't want guns if they weren't dangerous. That's the reason that they want to have them, for self-defense. Just as Justice Breyer said in his dissent in Heller, the fact that a handgun is the quintessential self-defense weapon, and that same fact is what makes it particularly dangerous.
right, but a registered gun would not, like you said, and I think we all agree that would not lead to the eviction of this Mr. HATTIX, right?
But I don't think you get to flaunt the law, and I don't think you get to say that the statute is irrelevant or cannot be applied because you don't think you fall under those requirements. And there's been nothing on the record to attack the constitutionality of the registration statements or its purpose. So I think that is what the law is, and that is and they've defined what the danger is. And that's the basis for the argument that guns are more dangerous and you're more of a threat if you're not registered than if you have been registered.
And sorry, I have one more question as well. So in the event that we disagree with you on per se and individualized and reverse, what result? Does it mean that he has the opportunity to cure, or that he just gets to stay in his unit?
I think we would have to go back to the court and get more and have additional information so that those items could be, if that's what the direction of the court would be, so that we can present evidence regarding the individualized threat.
Thank you, Ms. Dessel.
Thank you. We would just urge the court to uphold the judgment below.
All right. Thank you. Ms. Crum, we reserved a couple minutes of rebuttal time for you.
Thank you. I just have a few quick points here. I would note that counsel, when asked about the hypothetical where someone forgets to register the second gun that they had, her response, of course, was, well, we need more facts. We need to look at it, which implies we need a totality of the circumstances. We need to consider the individualized threat here. I'd also note that regarding the nexus and what was found below, Judge Boucher and Judge Edelman both found a nexus only based on the idea of location. And as I stated before, I think Whitfield was talking about something other than location, because it very specifically held out the fact that there could be an instance where a crime is committed off the property, but yet it still affects the tenants. So nexus is not solely about location. And in terms of authority, I don't believe there's any binding authority on this court regarding your question, Judge Beckwith. But I would point the court to under 7250501 3AA sections 1 through 3, which are the definition section of firearms. The DC Council went to the trouble to note that assault weapons and the weapons that are not allowed are a danger to the threat and safety of DC residents. Nowhere else in the statute does that appear. It does not appear when they're talking about handguns that are allowed or other guns that are allowed. It doesn't appear in the section about if there's a failure to register, whether that would be a threat.
Is it referring to the First Strike Act? That
No,
language?
it is not referring to the First Strike Act.
What is it referring to?
It is it's referring to the definitions. And so there's, I don't know, through DD or something of all the different types of weapons you cannot own. And then subpart 3 there specifically says that the chief, meaning the chief of police, can also deem anything else such that is like an assault weapon a danger to the threat and safety of DC residents.
Okay,
So it's a
it
definition.
uses very similar language to
It uses very similar language, but only to refer to weapons that are not allowed under any circumstances.
But I don't think there's much difference between what you just said about that language in the statute, not distinguishing between assault rifles and the kinds of weapons that aren't allowed under Heller or any other circumstance. I don't see Ms. Dessel disagreeing with that argument. What she's focusing on is the increased threat of unregistered firearms because of the, I'll call them protections of the registration statute here. And we talked about this a little bit on your direct examination, that the reason that we don't know more and don't have more facts here in part is Mr. Hattick's failure to comply with the law that requires him to register, where we would have had that additional information about whether he is an increased threat, has mental health issues, prior criminal record, or any of the other things that the registration statute is supposed to protect against.
But what we do have below is Mr. Hattick's testimony that indeed he would have qualified under the registration statute, that he would have been eligible to register these guns, so that he wouldn't fail in that way. He did not. He was convicted of attempted failure to register, but he does actually qualify, and that is his testimony about that.
Is that established or disputed? What's the status of that testimony?
The status of the testimony is that it was not disputed, and in fact, it was counsel sought to have it not be entered in any way. It was objected to. Judge Boucher allowed him to answer the question that yes, he is eligible, and then nothing further. So there was no
is it something he's able to know? Can he know whether he's eligible or not without jumping through the hoops, going through the process?
Well, certainly you can review the different checklist requirements that, you are required to do in order to register a gun and make that determination. Is there a formal determination? Of course not. That's why, there is no registration document, but I think anyone can look at that list and say, I meet these or I don't meet these. And we could have had more testimony about that, but we don't. Again, we have a very scant record here in terms of things.
Thank you very much. We
Thank you.
appreciate counsel's arguments and your briefs. The case is submitted. Thank you. All right, our third and final case this morning is William Donnette Saunders versus United States.
All right.
All right, good morning, counsel. Are you ready to proceed?
Yes, I am, Your Honor. May it please the court. I'm Tom Heslop. I'm here for Mr. Sanders, whose connection to the target.
Did you want to reserve any time?
Yeah, I would like to reserve like 2 minutes.
Okay, thank you.
His connection to the target and the target apartment was too tenuous to justify treating him under these cases, which set an exception to the Fourth Amendment. There is Summers is an exception to the Fourth Amendment, and it's an exception that requires under Summers that, I mean, that Mr. Summers was the owner of the house. He was present on the premises of the house, obviously an occupant of the house, and he let the police into the house. He facilitated their entry to the house.
I guess what, oh,
Sorry, I was gonna just take you back a pace or two. Here we have a claim that Mr. Saunders' Miranda rights were violated because he was detained and in custodial, he was in custody and interrogated while he was in custody without being read his Miranda rights.
Right.
When the police tried to execute a warrant on Mr. Stanley's
Right.
apartment unit and saw Saunders in the building coming out with Mr. Stanley. And the police stopped him and then took him back, questioned him, and the government relies on Morton and other cases that say the police were within their rights to detain Mr. Saunders because he was connected in some way to the premises where the search warrant was being executed. So I guess walk us through why you think he either was wrongfully detained and then in custody and interrogated in violation of Miranda.
Right. First, the wrongful detention. I mean, his body was seized and his property was seized and used to investigate him. So that's a Fourth Amendment problem right there, to which the government must offer a cogent exception. And they don't have one here because
They do cite Morton. I think it's Morton, or they do cite to Morton, which I believe is a case that they say allows the police when executing a warrant like they were here in an apartment unit. Am I
I'm
citing
not
to
sure
the
that's
wrong
Morton.
case?
I think Morton's more
I keep saying
directly a
Morton, but-
Miranda case.
Which is the one I'm referring to? Well, you tell me why it's not, and I'll find my case site. I keep saying Morton.
There are like 3 or 4 cases here, and Morton was more to the direct Miranda, which you know we can get to, but really the whole thing should end with them in the hallway. He's not anywhere. He's never been in that apartment, and the idea that they have some kind of reason to believe he's armed is just not there, because even if the search warrant here did mention guns, but they mentioned guns in the apartment connection with Stanley. That what the
They
government
do
has-
say there wasn't there testimony from one of the officers who says that through the window outside, he sees Saunders appear to be talking to Stanley.
someone in the apartment. He was talking to someone in the apartment. He's at the door. He never went into the apartment. Somebody came out of the apartment. And they walked down the stairs.
What
That's-
is the evidence that, evidence or lack of evidence about whether Sanders and I guess Stanley, but definitely Sanders knew the police were approaching or in the neighborhood, you know, like that they might have left the apartment because the police arrived? Is there evidence on that?
None. In fact,
Is
in
it
fact, the police see
inferable?
him- The police see him from the street through a window that they can look onto the second floor. Is just no indication whatsoever that
They can see him, can't he see them?
Well, he could, but they never said he did.
Mhm.
And it's not like they're hurrying away. It's not like they went up to I don't know if there was a 3rd floor, but it's not like they made an effort to escape. They just were walking down the stairs, and the police coming up the stairs to search the apartment stopped them. There's nothing.
Mueller and Germany, I apologize, were the 2 cases I was trying to
Right,
call,
right.
and I kept citing to which
All of those cases are cases, well, the case about the marijuana tent, the guy had been on the premises and came out. Germany, the guy was on the premises and was kept there and patted down. All right, and they when the pat down itself discovered the actual drugs.
now why is that? How do you distinguish Germany from what happened here, which is, I
Well,
think the government says is consistent with Germany,
Mr. Sanders was never on the premises, and even if
meaning in the unit. He was in
never
the
in the unit, he was
in the
on
building.
he was in an apartment building in a common area. Now, the thing about this is In Germany, when they patted him down, they discovered the contraband. So the question was simply whether they should be able to pat him down. In this case, they did search Mr. Sanders and didn't discover anything other than his car keys, which they then seized without any probable cause. All right, and took and located his car. Not for that, despite the somewhat tenuous argument that they inevitably would have discovered that. If not for that, they don't have anything against him.
So the questions that police ask him when they stop him on the steps, take him into custody, are questions that they contend, the government contends, are basic, custodial stop, kind of Terry stop like questions, for lack of a better word. What's your name? What are you doing here? Then they ask him about how he got there, and that's leads to a further line of questioning. What's wrong with that line of questioning? Why is it interrogation and not just initial investigatory questions?
Well, it is an investigation. They have a reason to suspect that he's connected to this apartment. They want to explore it, and they're investigating him, specifically him. All right, not just the apartment. That he's a separate investigation that they're undertaking right here. I mean, of course, it's interrogation. The police officer testified that they detained him for investigative purposes, directed at him. All right, and they took his keys and they kept his keys, and they never gave his keys back. All right, they gave him his money back, but they also introduced evidence at the trial about how much money he had, which was almost $1,000. Apparently, they must have counted it to know that, and so they've made a seizure of his body and his property, and there's no exception that applies.
Do you agree that, I mean, this is mixing the Fourth and the Fifth Amendment issues, but that it's a Terry stop, or that, the Supreme Court has generally seen this like holding people while a search warrant is executed to be akin to Terry or to be Terry? And so do you think that that's what it is? And is that enough to constitute custody under Miranda?
Well, it's not a Terry stop. I mean, according to the government, it's not a Terry stop. It's just, it doesn't even have to have articulable suspicion. It's just a search thing. But if you want to throw that out, which you should, then the question is, well, if it's a Terry stop, what should happen then? And then they may be at the stairs, would be able to pat him down and find his keys, but they couldn't keep his keys. They couldn't cuff him when he's obviously not dangerous. Why would they take him into a venue where they do suspect weapons are present when they have him outside that venue where he's not any longer a danger? So what are they doing here? They're trying to lock him up. That's basically it. And in order to do that, they cuffed him, they transported his body into a more dangerous place, and they interrogated him to try to get evidence against him, figure out whether they could do it.
Do you have any case law that involves, this interrogations that occur during the execution of a search warrant on a property, on an apartment or a house, where, a court discusses this sort of thing that he's, okay. it's nothing.
I haven't been able, well, certainly not in this jurisdiction, and I think the government may have cited a circuit case, but I don't even think that. And so I think that, you really, that's kind of I mean, look at it from Mr. Sanders' point of view. He's just there on the stairway with his acquaintance, if he even is an acquaintance, and then all of a sudden the police take custody of him, handcuff him, search him. There's no, by the way, since the hearing here was limited, there wasn't any hearing on the 23-110, and the hearing here at the trial level was limited to Summers, and so there's a lack of evidence about the actual sequence of what happened, when they can't handcuff him, when they talked to him. My impression is they took him in the apartment to talk to him, and while they were searching the apartment, they talked to him, not on the stairs.
Now you tried to the Bingham case was decided after the incidents in this case, and I think you distinguish somewhat between Bingham and Germany. Would the outcome have been different if Bingham or the applicable law here?
Well, you mean in front of Judge Leibowitz? Probably not,
Well,
but
no, that's not exactly what I was asking, but in general,
the thing about it is, what Bingham establishes is that the police, in order to search somebody that they think may be armed, have to have some reason, some articulable suspicion, if this is a Terry stop, to think that he's armed. And they didn't in this case. And even if they did, and they patted him down, after that, they seized him and his property, and for no apparent reason. They should have just told him to go away.
now, what do you make of appellant in his 23-110 ineffective assistance of counsel claim argues that trial counsel didn't make certain arguments related to the motion to suppress that were relevant here, that the trial counsel's argument focused mostly on the interrogation and the custody, but not the seizure of his keys and property.
That's right. They didn't move to suppress the keys and the money, and that evidence, if the government is going to argue inevitable discovery, the way you understand that, and there's a third part of this brief, which shows that somebody else testified and took the weight. So this isn't just a case where they found a whole bunch of drugs in a car that he owned. It's a case where they found a whole bunch of drugs in a car that he owned, and someone else said that it was their drugs.
Well, not someone else, the person whose apartment unit he was standing outside of, who police said he was associated with, or the government claims he might have had some associate.
Right. Regarding harmlessness, though, that testimony certainly brings up the idea that connecting Mr. Sanders' possession of the keys to the car and $1,000 certainly would give the jury a reason to think that he must have been more associated with the car and the drugs than not.
Was
And
it
so-
in your brief that I read a comment that Judge Leibowitz predicted an acquittal? And is that accurate? And what was she talking about?
She was very annoyed when the United States presented this evidence. And
This evidence being what?
Hmm?
When the US presented which evidence?
the evidence from Mr. Stanley, they
Okay.
called Mr. Stanley, not the, I mean,
Oh, okay.
I doubt that the defense would have called him, but the government called him and introduced all this evidence that he was the guilty person and that Mr. Sanders was not the guilty person. And so she was annoyed that they did that. And she, I mean, if you're the judge, you probably shouldn't say this, but she did say it, that she was annoyed and she thinks, the jury was good. And so she reserved her MJOA until the jury convicted, which I guess is a standard tactic. And then she did what she did.
Okay, so she was referring to, it was like a sidebar or something,
Right. She was unhappy with the prosecutor for introducing evidence that tended to show that Mr. Sanders was not guilty.
I wanted to ask you one other question about Germany, which I think may have been resolved by the language of the actual search warrant. Because initially in the brief, she argued that Germany didn't allow for the search or the taking into custody of Mr.
Right. That's a mistake
Saunders.
because the warrants once I got and read the warrant, the warrants are pretty much identical. And so I would draw that part of it, but I still say to you that they did not have any articulable suspicion that this man was armed because of his tenuous connection to the person that they're targeting and to the target apartment.
Okay. All right, we'll reserve your time for rebuttal. Thank you, Mr. Hess.
Thank you.
Counsel, you can adjust the podium if need
Oh.
be, needs to.
Thank you. Now, let me just bring this
Okay,
up.
thank you.
Good morning. May it please the court. Mark Hobel for the United States. Judge McKenna did not err in denying the motions to suppress. Judge Leibovitz did not abuse her discretion in denying Sanders' ineffective assistance claim, and the evidence was sufficient to convict on all of the offenses. I'd like to begin with the Fourth Amendment and effective assistance of counsel issues, and be sure to draw a clear distinction between what is preserved and what is not preserved in the subject of the collateral attack on the conviction. With respect to what's preserved, that is the detention incident to search, which is governed by Michigan v. Summers and its progeny. Michigan v. Summers says that anybody who's in the immediate vicinity of residence where police go to execute a search warrant may be detained, categorically may be detained without anything else for the duration of a proper search. That's precisely what happened here, and Judge McKenna
And
made
that's
that.
Germany. You include the Germany case that I keep asking about as
That's-
well.
That's correct. And Germany in this court extends that to the lawfulness of a protective frisk of anybody who's detained incident to a search where the search warrants for weapons. And we all agree that this search warrant.
So let me just ask you, what was Mr. Saunders detained for?
He was detained incident to the execution of the search warrant.
Okay, so he's in an apartment building in which Mr. Stanley's unit was located, right? So he's not in Mr. Stanley's unit. So are you saying that Michigan and its progeny would allow anyone in an apartment, multi-unit building to be detained when one unit has a search warrant being conducted and executed?
No. It's the test is immediate vicinity, and here we have the testimony from the officers. They saw him Sanders standing at the threshold to the specific apartment they had the search warrant to, talking through the open door. He then
And they saw this, I guess this testimony wasn't challenged, but they saw this from outside, looking up and into what was a hallway window in a public area, but they could see that Mr. Saunders was talking to someone in a private unit?
That's correct. There was a bay window. They could look up through the bay window. And I should parenthetically note here, Judge McKenna credited this testimony.
Okay.
They could look up through a bay window, see Mr. Sanders speaking to somebody inside the apartment. The testimony was that they saw Sanders and Stanley, the target of the search, the owner of that residence, walking down the stairway of the apartment building to a landing immediately beneath the apartment, which is where they stopped them. And so Judge McKenna does find, I think this is predominantly a factual finding, that he stopped within the immediate vicinity of Stanley's apartment, the target of the search warrant. I note too that in the Summers case, the Summers involved, and it was an owner of the residence. But I don't think that makes a difference here because Summers is categorical authority to detain those associated with the residence. It involved the owner of the residence who was, I think, coming down the walkway in front of his house. So it's a similar distance. We're not talking about a case like Bailey v. United States, a Supreme Court case from 2013, in which the Supreme Court said you can't detain somebody who's like a mile away. Clearly, they're.
So if we agree that you got the first prong, if we were to agree with that, to satisfy the Miranda question, Fifth Amendment, I'm going to now.
Right.
What about the second prong? The questions that Mr. Saunders was asked when he was detained, if we were to agree that this was a lawful detention while the search warrant of Stanley's apartment was being executed.
Right. So I just to make sure I understand Your Honor's question, you're asking now about the suppression of the statements issue and whether this was custodial interrogation under Miranda.
Correct.
Right. So our position is that a lawful detention into a search pursuant to Michigan v. Summers and its progeny is essentially the equivalent of a Terry stop. And in a Terry stop, police are permitted without Mirandizing to ask a limited series of questions to investigate or confirm or dispel their
I
suspicions.
think that's right as far as it goes. And so I think asking his name, sure, but like, why did they care how he had gotten there, where his car was, if not for an investigative purpose, not a sort of typical Terry purpose?
Right. I think they're one and the same. A Terry stop has an investigative purpose. And this is language taken pretty much verbatim from Berkham v. McCarty, which held that a Terry stop, generally speaking, is not Miranda custody. You know, the point of a Terry stop is to ask limited questions to confirm or dispel the suspicions that precipitated the stop. So just because they have some limited investigative purpose, in this case, their investigative purpose is to figure out, we're here to execute a search warrant for drugs, for a gun. This is a person who's seen exiting, you know, walking away from this apartment with the target. What is his connection? Do we need to worry about this guy?
Why does asking about the car serve that purpose?
Because he volunteers to them. I arrived, I drove here in a car.
No, they asked
mean
him how he
voluntary?
got there.
They asked him how he got there. And I think that's reasonably, as Judge McKenna found, reasonably connected to the trying to figure out what his connection to the residence is. You know, how did you get here? What's your association? And then to follow that up with, you know, okay, you have they asked him what the make and model was, where it was parked. He tells them, and they want to, at this point, I think principally confirm that he's telling them the truth. That is what he is, that his car is actually parked outside. And so on the basis of his statements, principally, they go outside.
Are you suggesting that they're trying to establish whether he lived there and therefore he didn't drive there, or because I guess I know I'm struggling with the relevance of his car, because then that leads to a whole series of that's really the whole basis for the charges against him, is what's located in the car. So I'm trying to figure out why the initial Terry stop like questions, why it was relevant to ask him how he got there and what he was driving, and then we get to the seizure of the keys. But just walk us through that.
I think the relevance was that you know, they were trying to just establish what his connection was to Stanley, what his connection was to the apartment, and if he's saying he doesn't live there, how did he get there? I'm not sure that you know, I also think that it you know, to the extent that they're not asking him about what's in the apartment, that just sort of underscores our point about this is not Miranda custody. They're not confronting him with evidence of a potential crime like the Morton case.
Do you know in the sequence, I'm sorry to interrupt you, whether these questions were asked when they took him back up handcuffed into the apartment, or whether they were being asked on the landing of the steps when they were first encountered?
I believe the testimony from Officer Thomas was that it was in the apartment.
Assuming that he is in custody, which I understand you disagree with, but what are you their booking questions are allowed? Can you say a little bit more about how these questions are not, you know, likely to elicit incriminating response, as they of course did?
Sure. And we've addressed in our brief sort of the preliminary relatively routine nature of the questions. I don't want to belabor that point. I would go at this point just to say, even if you assume that there's a Miranda problem here, you don't get to suppress the contents of the car, which under United States v. Patain, all you suppress is essentially statements that establish his ownership of that car. And that was a subject that was just not disputed at trial. The party stipulated that this was his car. His mail matter and other personal items are littered throughout the car. So even if you see a potential Miranda problem here, and we submit there's not, but even if you do, it would be harmless beyond a reason.
But how do they know even to look for a car of his without the statement?
No, I think that it was because of the statements, but my point is that even under United States v. Patain, the statements, you cannot suppress the physical, tangible evidence they discovered as a result of eliciting those statements. What gets suppressed is the statements themselves. So the Fourth Amendment analysis here is a little bit different. I do want to return to that, but I want to be really clear on this point that under United States v. Patain, even if you find that those statements should have been suppressed, the fruit of those un-Mirandized statements does not get suppressed, and the government still brings in the evidence that's been found in Sanders' car.
What are the facts in Patang?
I don't recall the specific facts of Patang, largely because its holding is so clear and doctrinal, which is that that you do not get to the fruits of unsworn, because Miranda is a prophylactic rule largely, the fruits of an unsworn statement do not come in, do not get suppressed. The physical fruits. The statements themselves may under certain circumstances, but the physical fruits don't. So the Miranda issue, again, we submit that this was effectively the equivalent of Terry stop, not custody. But if the court is concerned about that, this was harmless. The introduction of those statements against Sanders was harmless beyond a reasonable doubt. Returning, if I may, to the Fourth Amendment issue, because I want to make sure to address the unpreserved aspect of this, the substance of the ineffective assistance claim. And here, and again, in the interest of time and cutting to the chase, I'm tempted to just say Sanders has really done nothing to put a dent in Judge Leibovitz's careful, considered, inevitable discovery finding, which is amply supported by the trial record. And she was the judge who presided over trial, heard the testimony of the relevant witnesses. And what she finds is that the police the police are already looking for and are already interested in Sanders' car on the basis of what he's told them before they go into his pocket and remove the key. And the only role the key plays here is to confirm that the car is his. It's the equivalent of you or I forgetting where we parked our car in a crowded parking garage and beeping the key fob to figure out where your car is. It's nice to have it to confirm, but you're not just going to walk away and forget about your car.
Why are they looking for his car at all? I mean, so he tells them in a Terry stop, my name is, and I drove here. I mean, this is where I'm having a little bit of trouble with the inevitable discovery piece. Based on that, the gun sniffing dogs are going to be called out just by him saying I drove to visit my friend?
No, so I'm sorry. There's an intermediate step, and this is the sequence. They ask him how he got there. He says, I drove and my car is parked outside and it's a Chrysler 300. It's by the next building. They go down, they get the key from him. They go down, confirm that his car actually is there. Then Officer Thomas testified he actually went back up to the apartment, continued the search of the apartment because they've confirmed that, on this point at least, Sanders is telling them the truth. And then it was actually as they were discovering contraband drugs, a gun in Stanley's apartment, he looks at Sanders' face, and Sanders has got this weird blank expression on his face, like he's just processing what's going on. And that aroused the officer's suspicions. And that's when, during the course of the search of the apartment, they called the gun sniff dog to investigate that suspicion. And of course, there's been no challenge here to the gun sniff dog. The police didn't go into the car at that point. Once the gun sniff dog alerted, they went and got a warrant before they searched the car. There's been no challenge to that procedure. The only basis for the ineffective assistance claim is that somehow in the midst of this hearing, the public defender service attorney should have recognized that that he should have also argued, well, you should suppress the keys and the money that were found that were found on the Sanders person during the course of, and again, the police, I'm not sure we're even disputing at this point that the police could conduct a lawful pat-down search of him under Germany v. United States, given the similarity between these two warrants. So the keys and the money are the only items that are in dispute in the ineffective assistance claim. it's the inevitable discovery finding that I think we can, I think we've made our arguments about why the keys and the money themselves are not suppressible and why those are not a valid subject of a Strickland claim here. But even if you,
And that is
yeah,
why, because they weren't raised in the motion to suppress?
because there is, yes, because there is pre-existing authority, and we cited United States v. Bailey, a Second Circuit case, that in the course of this of a Terry type detention and frisk, police can remove hard objects from somebody's pocket. If they're keys, if you're detaining that person, they're not leaving anyway. And so holding on to the means of their departure does not occasion an additional
Sure, but like then they use the panic button to locate the car, right? I mean, what case says that that's permissible?
right. So this was, and there's actually a DC Circuit case from 2014 called United States v. Williams, and I'd be happy to submit this as a 28K letter that on plain error review held that, recognized that that using a key fob to identify the location of a car, there was no precedent from the DC Circuit or any other circuit that said that was an unlawful search. And we can submit that case on a 28K letter because that.
Do you have the site?
I do have the site. Sorry. Yes, United States v. Williams, 773 F3rd 98, DC Circuit 2014. There is not controlling precedent or clear legal norm regarding the activation of key fobs. Neither this circuit nor any other has held that an officer's warrantless activation of a key fob to locate the vehicle to which it corresponds constitutes a search, let alone an unconstitutional one. And that's a couple of years before the suppression hearing here. So, competent counsel, if they're keeping up on the law, and at least the sister court of this one is aware that that's the using beeping the key fob is not going to be a fruitful argument to make in a suppression hearing. With respect, I don't know if the court wants me to address the sufficiency claim. I don't believe Mr.
Can I ask you, and I'm not sure if my colleagues want you to address the sufficiency claim, but I just wanted to ask you again about the inevitable discovery doctrine.
Mhm.
How just walk me through the high points of that again.
Right. So the legal background and here is just that if the police are, we would need to establish by preponderance of the evidence. And it's a little unclear in this collateral context who bears the burden, but just assume we do. We would need to establish by preponderance of the evidence that the police have already started the type of investigation that's going to lead them to the evidence before they take the Fourth Amendment, the problematic Fourth Amendment step, in this case, removing the keys from his pocket, and that they actually would have discovered the contraband in the car. So
was that step leading to the discovery, the answer to the question, how'd you get here?
That's correct.
So if those statements were, in our view, in violation of Miranda, and they were elicited through a custodial interrogation, would that still be considered a preliminary step in your inevitable discovery?
Yes, it wouldn't matter, and that's because of United States v. Patain. I mean, if United States v. Patain says you even if those if there's a Miranda problem, you can't keep that, you can't suppress that evidence at trial, you can't keep it out of trial. It wouldn't make a whole lot of sense to say, but it also can't form a basis for the inevitable discovery fruits analysis. So yeah, I think those are I appreciate the question because I think those are completely distinct. I don't think the court has to worry about the statements in its inevitable discovery in assessing whether Judge Leibovitz correctly found an inevitable discovery here. And of course,
So if we exclude the statements or ignore them, or then what other factors here? We have the key fob, which was taken off of his property, off of his person. And your argument would be that that was not suppressible because of, was it Bailey or Williams? And then we'd have the dog,
Right.
gun sniffing dogs who know which car to sniff now because the key fob was used.
Right. So this is, the inevitable discovery is solely limited to what would have happened if they didn't recover the key fob. It doesn't, the statements don't matter here, because again, whether you think that the statement should have been excluded from trial.
So if they didn't discover the key fob, we're not focused on the statements, then what else led to the inevitable discovery of the car?
So
I mean, the guns and
Right.
drugs in the car.
So what Judge Leibovitz finds, based on Officer Thomas's testimony, is that they've already learned from Sanders himself that his car is parked on the street, and that they, as a result of his statements, they go down to check where the car is, and that's how they find it. That the key fob plays just an incidental, really unnecessary role in locating the car. That's what Judge Leibovitz finds, and she's inferring from those facts that the police became interested in the car, that the police would have gone down and looked for that car in the absence of the key fob. And that's totally reasonable, given that and supported by the record, given that Sanders has told them exactly where that car is, exactly what make and model it is. It's not far away. It's just parked in the street by the next building.
I mean, you have sort of like very technical legal responses to like, well, they can get the key fob, they can hold on to the key fob, they can beat the key fob. And like, it just seems like we're sort of building this like sandcastle almost, right? I mean, they came to execute a search warrant on an apartment, right? They end up then devoting significant resources to investigating this car outside that happens to belong to one of the occupants. And it seems to me that like, we're just getting really far afield of what seems to be sort of reasonable, whether we're envisaging it through the Fifth Amendment or the Fourth Amendment.
So I think that, I want to, Your Honor's question, the spirit, I think Your Honor's question is the facts here are a little unusual in that they come to execute a totally valid search warrant on Stanley's apartment, find what they're looking for, drugs and a gun, and they also come upon this guy who seems to be clearly associated with Sanders, and they decide to they get interested in him too, in part based on his initial presence there and his association with Stanley, in part based on the way he's acting as they're executing the search warrant. And I understand Your Honor's point about this seems sort of like technical in a sandcastle. And in part, this is because, you know, we're dealing with a lot of these claims in a collateral proceeding.
Can I just interrupt one of the bricks in that wall?
Yeah.
I thought that all the testimony was the way he was acting was very chill, like not giving the police any indication that they better check him out too.
I think the exact testimony was, you know, he had a blank look on his face, like he was just processing something. And you can sort of imagine if you know, an innocent person who had no idea what was in Stanley's apartment, the drugs and the gun and so forth, was sitting there detained pursuant to Summers during this search. You'd sort of maybe expect to see a little bit of surprise or shock, but here this guy is just sitting there
Processing a lot. Like, I mean, he could have been the DoorDash driver for all we know, right? And then
Right.
he's handcuffed for 2 hours and asked a bunch of questions and his car is impounded and searched, right? Just.
No, I agree. It could be the DoorDash driver. I think that's a good reason why it's important that police are able to ask these types of questions to establish who are you, what's your connection.
It's for his
It could be
good.
the DoorDash guy. Sorry.
It's for his good.
What's that?
It's for his good too.
I mean, I think it's I think the way these documents have been built up, it's for the public good and it balances certain interests. Yeah, maybe it's not for his good if he's you know, working with Mr. Stanley in a drug trafficking operation, but if he's the DoorDash driver and you know, you before we say anything to you, sir, we want to tell you, you have the right to remain silent. You have the right to an attorney. Do you understand these rights? And the DoorDash guy is thinking, oh boy, I better keep quiet and I'll tell them I'm here to deliver pizza. And you know, that's not that's not in the public good. So I think the police, fundamentally, the police are authorized within the limits of the Fourth Amendment and the Fifth Amendment to investigate crimes in the community. And what we submit to the court here is that they stay within those limits. And certainly to the extent that there were other claims that could have been raised in the suppression hearing that the Public Defender Service Council did not raise. You know, that there is no Mr. Sanders hasn't established the Strickland prejudice that on the basis of those claims.
Can I ask, in a typical situation, this must happen so often when a search warrant is being executed in a home and the target or the person who lives there is sitting on the couch, maybe in cuffs, while the search warrant's being executed. And if the police question that person, do they normally give him Miranda rights? And what is the, you know, how much, I feel like your brief is giving the impression that as long as a search warrant's being executed, they can ask these people a lot of things that you wouldn't normally think you could ask without Miranda arising as an issue. What is your view of how much they can, you know, actually question the person they're really looking for?
I mean, I don't know the answer to what happens in a typical situation. I just don't. I apologize for that. You know, with respect to the outer limits here, I think we cited the United States v. Davis case from the Ninth Circuit involving pretty similar circumstances of you know, unwarranted questioning during a summer's detention. And
So Davis also says that there's some daylight between what counts as, you know, seizure for Fourth Amendment and custody for Fifth Amendment. Do you agree? I mean, I think earlier you tried to sort of say they're the same standard, but.
No, and I apologize because I completely agree that there is substantial daylight between them. Generally speaking, a Fourth Amendment, a Terry stop, which is a seizure under the Fourth Amendment. We all agree on that. A Terry stop is not custody for the purposes of Miranda. Custody for the purposes of Miranda is the functional equivalent of formal arrest, which of course is a higher level of seizure. So in a situation like this one or like Davis, in which a person is temporarily detained while police execute detained instant to the execution of a search warrant.
And does temporarily include hours while
Yes.
it's only temporary because it's while the search is going on?
That's correct. That's correct. And certainly the Supreme Court has recognized this can go for 2 or 3 hours. Here it was 2 hours. But while and I completely apologize to Jalika. I lost my train of thought there on the basis of that question.
Well, I'll ask you another question, because
Yeah.
it seems like I get what you're saying, that you're saying almost there's a higher standard for custody in the Miranda context than for sort of this detention. But I guess why doesn't that sort of work in reverse? And I'm thinking of Berkman here. So like you get the person, you get to sort of hold them while you're doing the search warrant, you get to ask them some Terry type questions. But the minute you go beyond sort of basic Terry questions, which I think that this car question could be, then it seems like we are in a custodial situation where Miranda would be required.
Right. And you know, I think the precise point at which the precise factual point at which you get there, you know, I think is kind of a factual point. And here you have Judge McKenna, you know, saying this didn't, you know, this type of questioning didn't rise beyond what you'd typically see in a Terry type scenario. And certainly the questions, if you look at the Davis case, the questions there, you know, do you know anything about this, your brother's marijuana operation? That is like way beyond what we have here. They're not even asking about the stuff in the apartment. They're staying away. I mean, in a lot of respects, though, I want to actually emphasize this point in closing here. In a lot of respects, the police here were very restrained. They gave Mr. Sanders his $1,000 back. They didn't search the car on the scene then. They went and they got a search warrant to do it. They didn't try to ask him about the stuff in the apartment. All they were trying to figure out is, you know, essentially, what are you doing here? How did you get here? Yes, you know, they did investigate suspicions. They had a right to do that under the Fourth Amendment, under the Fifth Amendment, but But there are steps that they that they arguably could have taken that they didn't take here. So I know I haven't addressed the sufficiency point. I'm happy to do that if the court has questions. Otherwise, we would just ask that the.
Could I'm sorry, just
Yes.
one question on sufficiency, because I feel like we have cases that sort of, like James and Rivas and that sort of cut different ways. And what do you think is the closest case with this, a scenario like this, that's in your favor?
I'm not sure it's the closest case, but I think the Evans case we cite, which goes into the law of constructive possession on a lot of detail, does talk about intermingled personal possessions with contraband. And I think that is the key detail here in assessing the sufficiency of the evidence of constructive possession is the Sanders' personal belongings, his mail matter, a pill bottle with his name on it, are littered throughout the car. And that in fact, there is an armrest in which you have both his car registration with his name on it and a digital scale, which is
What is the relevance of, like, I don't think he would disagree with any of that. It's his car, and that, a defense or a government witness actually testifies that he borrowed the car. What is the relevance of the Stanley testimony to the sufficiency claim?
It's certainly part of the picture and the evidence, but at the same time, the standard of review here is such that this court has to presume the jury discredited Stanley's testimony, and of course, it had plenty of reason to do so. He was immunized. This was his friend. Is
that right? So is that most favorable? Discredit anything that's good for the defense? Is that what that means?
I think that the broadly stated, yes, Your Honor. I think that to the extent that there is a factual question, and it's, for example, was Stanley telling the truth, or was he, trying to cover for his Confederate? It's got to cut in favor of what we, the prosecutor, asked, even though it was a government witness. And what we asked the court to, what we asked the jury to do, which is to discredit him. And I just note that Mr. Heslop says, it was it was doubtful that the defense was going to call Mr. Stanley as a witness. I mean, respectfully, that is, Mr. Stanley was immunized at the behest of the defense here under the procedures of Carter. He was the defense attorney repeatedly, indicated that he was likely to call this witness. And at the end of the day, this prosecutor made a strategic decision. And trial lawyering is an art, not a science. And so to the extent that Judge Leibovitz thinks that this was and said, I think this is a dumb idea. It actually was a successful trial tactic, judging by the jury's verdict. But I think that it's certainly, we're not saying that Stanley's testimony is not part of the picture here on sufficiency. We're just saying that in the light most favorable to the government, the jury could and did discredit Stanley's biased testimony, and that was able to find constructive possession just based on the overwhelming evidence in the car itself.
Great. Thank you, counsel.
Thank you.
Appreciate your arguments. Mr. Heslop, we reserved a couple of minutes for rebuttal.
Oh, I knew that would happen. So I'll do without it. One, in terms of the sufficiency argument, I just want to point out that Mr. Sanders' cross-examination of this witness brought out that he made the same inculpatory statements before he was granted immunity to a defense investigator. So he made statements that these are in effect statements against penal interest, even though the sworn testimony may not have fit into that category.
That doesn't make them true, though. That doesn't make them true.
No, it doesn't. And just, I just well, they emphasize the immunity and that's a big point, but on the other hand, he wasn't immunized when he made the statements to start with. Now, inevitable discovery was not really litigated below, and I don't know how we can suddenly make a determination that, it was going to happen. Nobody ever asked these police about that.
Well, did Judge Leibowitz make any statements about inevitable discovery in her findings?
The judge made those findings based upon sandcastles, basically. I don't know how she presided over the trial, but never was that an issue at the trial or at the motions hearing or anything like that. It was not an issue that was litigated by the defendant. And so why are we suddenly, you can say that, and the judge can conclude it, but she didn't have any, let's put it this way. She didn't have any reason to conclude it, a good reason. And
so if to the extent that she found or concluded that the evidence in the car would have been discovered, how much are we bound by her determination? What part of her determination was factual finding, which we might not be inclined to disturb? What part of it was a legal conclusion, which we would review on appeal?
Well, almost all of it is a factual finding. She has to conclude that based upon all the facts here, it was inevitable that the police would go to the car and do that. And her conclusion, that's one. And her conclusion is not really based upon anything. But two, her conclusion comes out of the blue after the matter hasn't been litigated. And so, if you're going to deny a motion and a 23-110 motion, and you're gonna do it on inevitable discovery, at least you should have a little hearing and say, well, why was it inevitable, and then have evidence on it.
Well, do you agree under, I guess it's Bailey, they could have taken and held onto the key fob?
All right, we'll get this in.
Take your time.
Okay.
Sorry, do you agree that, I think it's under Bailey, they could have taken and held onto the key fob?
And that
That they could have taken and held onto the key fob?
yeah, they took it, they seized it illegally, all right, and they used it to investigate. And that's just, I also want to emphasize here that the government wants you to seg out the Fourth Amendment and the Fifth Amendment claims. And, that's always a nice tactic. And they're saying, well, the Fifth Amendment claim doesn't involve suppression of the actual contraband. But the Fifth Amendment claim, the Miranda violation, occurred during a Fourth Amendment violation. In other words, if not for the Fourth Amendment violation, they wouldn't have any of the statements anyway. And so you can't segregate those two. It's the basic seizure of his person and his property that starts this whole thing.
All right, thank you, Mr. Heslop. We'd like to thank both counsel and for your briefs and your arguments today, and the case is submitted. Thank you.
Thank you.
All rise.